that we to attempt to obtain a DNA standard from the target of the hit and submit that to the lab for testing.
And so you would be required under the procedures of CODIS to get that new sample?
Yes.
So therefore, the relevancy and materiality that you state in your search warrant goes to just the comparison of the CODIS hit.
That's correct.
Does it go to any part of the previous homicide case?
No, I wasn't investigating a homicide. I was just getting a DNA standard.
Okay. And defense touched on a couple of different things that you've done in your career. You stated that you were a sexual assault detective for a number of years.
Well, I was a violent crime investigator, and at that time, the Violent Crimes Unit was tasked with investigating sexual assaults.
And did you ever investigate sexual assaults with homicides?
No, that would have been the homicides job.
Did you ever investigate late reported rapes?
Yes.
And can you describe for us what a late reporting rape is?
Well, sometimes you get a victim that reports being sexually assaulted or raped, and it could have just occurred that day, or it could have been within the last several days. Anything not the day of is considered belated. Anything 3 to 5 days, we would still perform a sexual assault kit on. Anything over 5 days, we wouldn't necessarily do a sexual assault kit anymore. And of course, we've had belated cases where adult victims report that they were assaulted as a child. Obviously, you can't do any testing in those cases. Or if somebody comes forward weeks or months later, it's difficult to do any testing at that point. Our requirements are 3 to 5 days for sexual assault kits to be completed, maximum.
And you used to have to talk to those victims and find out what they've done within those 3 to 5 days?
Yes.
If they took a shower, would you still do a rape kit within 3 to 5 days?
Yes.
If they took a bath, would you still do a rape kit within 3 to 5 days? And why is that?
Because sometimes evidence can still remain, so it's always better to do and possibly find something or not find anything than to not do and not know.
Now, you've also worked in homicide.
Yes, I have.
And in those cases, have you ever seen cases where it initially looks like a possible one type of case, however, when you investigate it, the evidence shows you that it's actually a different type of case that you're looking at?
Well, sometimes, yes.
And looking and hearing about this case, would it be fair to say that you could go in looking at this as a possible sexual assault, but as you investigate it, as you looked at all the evidence, the physical evidence, the testimony of the individuals who were there present at the scene, that would change your view of the crime scene?
Objection calls for rank speculation, no foundation for this witness.
Overruled.
That's possible, yes.
Thank you. Yeah, ma'am, you've been working here for almost 17 years?
Over 17 years. It was 17 years in June.
17 years in June. And defense counsel handed up a exhibit number 32. I'm going to approach with that real quick. I believe it's the detective division. Do you have a copy of that up there?
Yes.
Okay. That document, how did you describe this?
It appears to be a summary of what's included in a investigation packet.
Investigation packet, could you please describe for me what an investigation packet is?
Well, there are usually two types of packets that are done. When I worked homicide, we would do an initial, what we would call a felony screening packet. And everything that we have from the beginning of the case to include notes, initial incident report, and any information up until an arrest is made, or within the first few, week or so of the case, we would do what's called a felony screening packet. And anytime a person is arrested for felony, you have to do a screening packet. And that doesn't have to be the whole entire case file yet, but it has to be everything you have up until that point, or at least the majority of it. And it's sent to the DA's office. And then down the road, we would do an additional entire case file for discovery purposes with everything once the case is completed.
And the way that this has been done,
Excuse me,
and
can we have a time period for that? That's okay.
that's what I'm getting into.
Oh, good.
Thank you.
And did you say felony screening? My hearing is, or thumb screening, I couldn't.
Felony.
No. Thank you.
Now, the time frame for putting those in and preparing them and the manner in which those are sent to the DA's office has changed throughout the years while you've been here, correct?
Yes, that's correct.
And while you've been here, do you recall how it was when you first got here, how those were prepared and done?
Well, when I first got here, they were just basically prepared and done at the point of an arrest. We didn't send anything over on a case until an arrest or a warrant was obtained. The person didn't necessarily need to be picked up. But once a felony warrant was obtained on a subject, you would get your stuff together and send it over. Now it's a 72-hour window. You have to, once a warrant is obtained in a case, you have to get that paperwork over in 72 hours. Anything that you have initially involved in that case to the DA's office so that they have it to prepare for, I guess, a grand jury.
But it wasn't 72 hours back then?
No, we didn't have a window back then.
No window. It could have been weeks, it could have been a couple of months.
We didn't have any specification.
Okay.
Can I just get, I don't mean to interrupt, but when you say when you started, so that would have been what year?
Your Honor, I'm sure that he's going to have an opportunity to recross.
No, okay, I thought you said you were getting to the time, but okay. I'm just confused as to what period we're starting with. When you say when you first got there, we know. That's fine.
I'll clarify that. When you first got there was when you were hired by the police department, correct?
Yes, that's correct.
Thank you. Now, when, what has changed now that allows you to get it to us in 72 hours?
I'm sorry?
What has changed that has allowed you to kind of get it to us a lot quicker?
Obviously, we have a better way of keeping records. We have computer systems now. We're able to access reports and materials a lot quicker. What made the decision for us to have a 72-hour window, I don't know. That comes down from the higher-ups above me, and they tell us, okay, from here forward, felony screenings must be completed within 72 hours of a warrant.
And that's because you can now just kind of type them into the computer, send them off to the,
Yes.
then get them looked at and send them off to the next person. Back in the day, you actually had to sit down at a typewriter and type out your reports, correct?
Yes.
And you had to actually have that typewritten report go to another individual to look at, correct?
Yes, it was before my time, but yes.
And then they had to go and pull all of this information from multiple sources that were not connected by cables.
That's
Your
correct.
Honor, I have to object. I mean, should we swear the district attorney? I mean, she said that this is before her time. So I object and move to strike anything about what she knows prior to 1999 without a proper foundation being laid, other than the district attorney telling us?
It seems like she doesn't know, really, Miss Ellis, about what happened before that she got there. You might know, but she doesn't know.
Well, Your Honor, she didn't quite know anything about all of the evidence that counsel put in yesterday, yet that's been introduced. She's merely stating what she knows about policy and procedures. And I'll ask her again, once again, were you aware of the policy and procedures?
Yes.
Why are you looking at me?
Your Honor, I'm just waiting for your ruling. I'm just respecting the court.
Well, I think she cannot have personal knowledge about things she doesn't have personal knowledge about now. So he'll have a chance to examine her about things he believes she doesn't have personal knowledge about. So go ahead, ask another question.
Thank you. So, in this case, he gave you this and asked you to identify it, didn't he?
Yes.
And you were able to identify it, correct?
Based on what it says on the front, yes.
Right. And he asked you questions about this document, correct?
Yes.
And have you since, and basically what I'm asking is, were you able to, after he opened the door and talked to you about this document, were you able to review it?
Briefly, yes.
Okay. And were you familiar with the policies and procedures and how to prepare and present the case files generally for screening reports?
Yes.
And how were they done as paper form?
As paper form, they basically were prepared. You had a case incident report, notes. Some investigators did summaries, typed up full summaries. Some investigators did a table of contents. Every investigative style was slightly different, but there was usually a format that was followed.
And the screening report, do you know how that was got to the DA's office?
It's usually sent into her office with a court liaison. He comes and picks it up at headquarters. We sign it into a logbook, and it's put in a bin at the front desk officer. And the liaison will pick up all the felony screenings and bring them to the DA's office.
Again, Your Honor, I would just ask that this be put in a time frame with respect to the witness's personal knowledge as to how the procedures work, because it is an issue in this case as to how they worked in 1991. She wasn't there yet.
What time frame do you believe you are accurately testifying about?
As far as
This-
felony screenings?
You say this happened at some point in time. Do you know a time that you believe this was the way it was done?
Well, since I've been here in 1999, that's the way it's been done, and to my knowledge, that's the way it was done prior to me. Now, who the court liaison was in 91 that picked them up, I don't know.
All right.
Thank you, Your Honor. Now, going back to the case where you actually served the search warrant for the DNA production. Now, counsel asked you a number of questions about your actions there. Now, going back and having seen that videotape and having reviewed the actions and words of Jermac Jones, based on your training and experience, what would you need to get a warrant for his phone?
I would
I'm
need-
sorry, is
His phone.
phone.
In order to obtain a court order for his phone records, I would need probable cause.
And can you tell us what probable cause is?
Probable cause is the probability of a minimum of 51% or higher that that person was likely the person to commit a crime. So, or that it's probable that what I'm looking for is going to contain the information I need to prove that that person committed that crime.
Now, you've reviewed that tape, and based on your training, experience, and knowledge of the case, did you, or would you have felt now that you would have enough information based on that tape to get that information?
Enough probable cause? No.
Why not?
There was nothing specifically said to any facts of the case to give me any probable cause to believe that he had direct knowledge of that crime or had partaken in that crime. I would need probable cause, not just reasonable suspicion. Now, did I have reasonable suspicion? Yes, but not probable cause to get a court order.
And this wasn't an open case, so you didn't look at the tape?
No, I did not.
And why was it not an open case?
There had already been an arrest made, and it was already adjudicated through the court system with a conviction.
And are cases open sometimes if they are found with CODIS hits or the like?
I imagine they could be. I don't know of any that have ever been since I've been there.
At the police department?
That's correct.
So you don't know what that standard is?
No.
And who gave you that task of securing the CODIS swab?
Sergeant Pennick.
And what else, if anything, did he ask you to do?
Nothing.
And based on your looking at the information that you've heard in the last 2 days, you're a competent police officer that's had a lot of training. Do you believe now that you would have any probable cause to go after anybody for this homicide besides Mr. Howard?
For homicide, no.
Thank you. No further questions, Your Honor.
Very briefly, you had probable cause to conduct an actual physical search of Jermac Jones and take his DNA, right?
With the CODIS hit, yes.
Right. That's because his semen was in the body, the vagina, of a woman who had been murdered, correct?
That's correct.
With apparent sexual assault of that woman, correct?
Whether it was a sexual assault or consensual, I can't say.
You didn't think that there was probable cause to believe that this might be a sexual assault and Jermac Jones might have been involved? That's what you're telling us?
I didn't have any probable cause to suspect that it was a sexual assault. I had probable cause to believe that his semen was present, but whether it was an assault or consensual, I had no way of knowing that.
You didn't think that when you asked Jermac Jones if he knew Doris Washington and he said no, and when you asked Jermac Jones if he'd ever had sex with her and he said no, didn't you think that that wasn't a truthful statement? Told us that yesterday, right?
Yes, but again, not evidence of homicide. possible sexual assault with no living victim.
So you have the semen of an individual in a dead woman at a crime scene that's an apparent sexual assault, and then he lies to you about knowing her and about having sex with her. Fair statement?
Fair statement.
And you're telling us right here and now that you don't think that that would be a basis of getting probable cause, even to get a search warrant to look at his telephone records of the people he called that we watched on that tape? That's what you're really saying?
Based on what was said, no, there was no probable cause.
Well, you were also telling us this wasn't an active case, right? As far as you were concerned.
It was not an open active case, no.
Right. All right. I don't. That's enough.
No further questions?
Yes, I apologize, Your Honor. No further questions.
Your Honor, I have no further questions for this witness.
All right, you can come back.
May she be released from her subpoena?
We have no objection to that.
Thank you.
Yes.
Your Honor, the defendant calls Jerry Waller.
Place your left hand on the Bible and raise your right. You solemnly swear that the testimony you shall now give the court in the case now being heard shall be the truth, the whole truth, and nothing but the truth. So help you God. Thank you.
Good morning, Mr. Waller.
Good morning.
Could you please state your name for the record?
My name is Jerry Waller.
And what is your occupation, sir?
I'm a licensed private investigator.
And how long have you been a licensed private investigator?
January of this year made 23 years.
And over the course of your 23 years, have you worked with me before?
Yes, sir, I have.
Who are you licensed by?
Licensed by the North Carolina Department of Public Safety now. Originally was North Carolina Department of Justice.
And could you just very briefly describe your background for the court?
Yes, sir. Graduated from high school, went in the United States Air Force from 1977 to 82. Did some investigation work in the Air Force. Completed my enlistment in the Air Force, attended East Carolina University, earned a Bachelor of Science degree in Criminal Justice. After that, I started work with the North Carolina Division of Adult Probation and Parole. Started out as a court intake officer, went up to parole officer, and then probation parole officer 2 in charge of intensive probation parole for Lenoir, Greene, and Jones counties. In January 1993, decided to get a private investigator license and assist attorneys.
At my request, Mr. Waller, did you perform some investigative tasks in this case?
Yes, sir, I did.
And was one of those tasks locating and speaking with Jermaine Jones?
Yes, sir, it was.
And did you in fact speak with Mr. Jones?
Yes, sir, I did.
And did you prepare an affidavit memorializing that conversation?
Yes, sir, I did.
Your Honor, if I may proceed.
Yes.
I'm going to hand you what's been marked for identification purposes as Defendants Exhibit 37. And can you identify what Defendants Exhibit 37 appears to be?
This is a notarized affidavit.
And who is that notarized by, sir? In other words, whose affidavit?
It's my affidavit.
Okay. And is this the affidavit that you prepared memorializing your conversation with Jermaine Jones?
Yes, it is. It's an affidavit that was prepared, yes.
Could you please tell the court about your conversation with Jermaine Jones, referring to the affidavit as you need?
Yes, sir, I will. On December the 13th of 2012, I met with Jermaine Mackey Jones in Durham, North Carolina at a Burger King restaurant. Nishonda Hodges, who described herself as Jones's ex-girlfriend, was also present. Prior to the meeting, I spoke with Jones over the telephone. I told him that I was investigating an old murder case Initially, Jones was reluctant to meet. I told him my name and I explained that I was not a law enforcement officer. He eventually agreed to meet me at the Burger King. At the meeting, I gave Jones and Hodges business cards with my contact information, and I noted on the cards that I was working with the Innocence Project. During our meeting, I told Jones that I was looking into the murders of Doris and Nishonda in Few Gardens. Jones says that was a long time ago and he was just a kid. Jones said he remembered the murders. He recalled that his mother woke him up the morning of the murders and said, she said, this is not in here, but she said the N-word, your girlfriend picture on TV, she's dead, her mommy is too. Jones said he walked down the Few Gardens complex to look at the apartment and could not believe it. Jones said that he had met Nishonda at a club about 2 or 3 weeks before her death. He and Nishonda had sex about 3 to 4 times during that period. The last time they had sex was the evening before Nishonda's death in the living room of Nishonda's friend's house. Jones said that after he and Nishonda had sex, Nishonda left telling him that she would see him the next day. Jones returned home to Maple Street where he was living at the time with his mother. Jones told me that this was the last time he saw Nishonda. I asked Jones if he had anal sex with Nishonda. Jones said he was young at the time and did not know anything about anal sex. Jones said that Nishonda's mother, Doris, was real strict and he never went to Nishonda's apartment. Jones said all of his contact with Nishonda was away from her apartment and or at Nishonda's friend's house. Jones told me that he was arrested in the summer of 2012 on a driving charge. During the booking process, he was taken to headquarters and a cop advised him that his DNA was on Doris and that it was a positive match when it was run through a database. Jones told the deputy he did not know how that was possible. He told the deputy that he probably needed legal advice. The deputy said he was going to collect Jones's DNA because he needed to compare it to the DNA in the old case. Jones said the deputy collected his DNA with a swab. I asked Jones how his DNA could be on Doris. He said he did not know. He said he never met Doris, did not know Doris, and had never been to Doris's apartment. Jones suggested that perhaps Nishonda could have transferred his DNA onto Doris. I showed Jones a photograph of Darryl Howard. Jones said Howard looked familiar, but he did not know him.
Let me ask you a few questions about that. You indicated that Mr. Jones's explanation for his sperm being found inside Doris Washington was that somehow Nishonda had transferred it to her. Did he describe how he thought that happened?
No, sir. He just said that's the only explanation he could give.
Okay. And knowing that his sperm was found inside Doris Washington, in your judgment, was he being truthful with you when he said that?
Repeat that for me one more time.
Yeah. When he said that he did not know Doris Washington, had never touched her, and had never even been in her apartment, in light of the fact that his sperm was found inside of Doris Washington and the bloody drainage in her vagina, was he being truthful with you?
Did not appear to be so.
Okay.
Your Honor, at this time I would object. He's laid no foundation that he knows Jermac Jones from before, or that he knows anything about his demeanor, or has laid any foundation that he could judge that. And on that ground, I would object, Your Honor.
Well, he's a private investigator. I think he could have an opinion about whether Mr. Jones was truthful or not.
Thank you, Your Honor.
Mr. Jones also told you that he'd never been to Nishonda's apartment because her mother was so strict?
Yes, sir, that's what he said.
You heard that during the phone calls he made yesterday, you were sitting in the courtroom and heard the interview.
Yes, sir.
And you've read a transcript of the interview.
Yes, sir.
And you saw that during the phone calls he made, he was telling a friend, don't you remember we used to hang down at Nishonda's house?
Yes, I did hear that.
So was he being truthful to you when he said he was never at the apartment, when he's telling a friend on a phone call that they used to be in the apartment?
Objection, Your
Overruled.
Thank you.
Does not appear so.
Now, let's assume for a second that Mr. Jones was being truthful when he said he had sex with Nishonda the night before the homicides. Let's just assume that. You know from the evidence, and if the court should find from the evidence and by its greater weight, that the semen found inside of Nishonda, in her anus, did not belong to Jermac Jones.
Yes.
What does that tell you as a private investigator?
That someone else had sex with her.
In other words, if Mr. Jones had sex with her the night before, then sometime before, between the time Mr. Jones had sex with her and the time she was died, somebody sodomized this child.
Yes, sir.
I have no further questions.
Cross-exam?
Yes. You stated that you got your private license in 1993. How'd you go about doing that?
I'd go about getting a private investigator license. I made an application with the Private Protective Services Board. They conducted an investigation and approved me for a full PI license.
Did you go through any sort of training?
Had to have 3,000 hours of investigative training to obtain the full license
And what type of training?
through probation and parole services.
So through probation and parole, not through protective? Were there any classes that you had to take your PI license?
No, ma'am. They have recently started continuing education, probably about 7, 8 years ago.
So basically you put money down and you got your license and camera and you're ready to roll?
No, ma'am. I did have to pay a fee, but I was investigated, and based on my prior military service, my education, and
Were
my
you-
training with the North
were
Carolina
you-
Division of Adult Probation and Parole, they approved it.
So you received all of your training with the adult probation and parole?
And through my education.
Now, in that, were you ever trained on how to speak with witnesses or trained on interrogations?
Was I trained how to speak with witnesses?
Mhm.
Yes, ma'am, I received training on that.
And tell me about your training.
That training was through continuing education with the adult probation and parole.
And that's, so let me understand, you continued your training through probation and parole as a private investigator?
No, ma'am. I've taken courses on my own and continuing education that's required.
Okay. And how long were you in probation and parole?
7 years.
7 years?
Yes, ma'am.
And during that time, did you go out and talk to witnesses in cases?
Yes, ma'am, I did.
Okay. And were you trained to take notes?
Take notes. Yes, ma'am.
Okay. And so you were trained to, when you sat down with somebody to take notes and to kind of memorialize what was happening at that time, correct?
Yes, ma'am.
And to look at idiosyncrasies and record those, because those are important when you're looking at a case afterwards to see what they were doing. Were they fidgeting? Were they playing with their phone or anything like that? Those are pretty important things, correct?
There'll be observations you can make.
Yeah, a lot of observations. Were you also trained that the best way to go about memorializing a interview would be to carry a recorder with you of some nature, either a video or an audio recorder? Do you do that?
Sometimes I do. That's not always the best way. Usually, sometimes when you're out in the street working, people see a tape recorder, audio camera, they'll shut down on
They'll shut down.
you, right?
Yet police officers, when they're investigating a homicide, are required to record and memorialize their interviews, even if people are going to shut down, correct?
Yeah, I think that law was passed a few years ago.
Okay. That law has passed a few years ago, and in 2013, that's only 3 years ago. That when did you do this? 2012?
Yes, ma'am, 2012.
So you're telling me that you have no notes on this?
I don't have any notes, no, ma'am.
No notes. So this is just your recollection of sitting down with this guy, talking to him at Burger King?
Yes, ma'am. This
And
is
you
what he
took
told me.
no notes?
I took notes at the time.
You took notes at the time. Where are they?
They were destroyed after the affidavit was done.
Excuse me?
They were destroyed after my affidavit was done.
They were destroyed. Are you aware that investigators and police officers who investigate are not allowed to destroy their actual notes pursuant to investigating homicides? Were you trained that in any of your private investigator courses?
No, ma'am. We didn't receive any training.
So
on
you
that.
basically destroyed evidence.
No, ma'am, I didn't destroy evidence. I took my notes, did my report, did the affidavit.
Overruled.
And destroyed your notes, which were evidence. Now, looking at that, you stated that you actually did this December 13th, 2012, and yet you did not memorialize this into notes and get it executed until September of 2013. How many months is that? Is that 9 months? 9 months later?
Yes, ma'am.
So you took notes that you can't give to us. You took no audio or video recording of this incident. You destroyed anything that we would have known that was created contemporaneously with your interview. And 9 months later, you give us an affidavit that's not even signed by the witness himself. It's just your recollection of what happened. So this is just your affidavit of what he said to you. But we have no way of verifying this.
I'm not sure what the question is, Your Honor. There were about 10 different parts. I object to the form.
Which one do you want him to answer?
Oh, you're absolutely right, yeah, Your Honor. That was quite a mouthful. But looking at this, basically, we can't tell exactly what your words were versus what his words were based on this, can we?
Tell what his words were, what he told me.
Just because it's what you wrote down and what you presented in your affidavit. He's never signed or attested to this. We have no, correct?
No, ma'am, he didn't sign this.
He didn't sign this.
No, ma'am.
And we have no notes that were made contemporaneously with your interview, correct?
At this time, we don't, no, ma'am.
We have no video that you prepared when you were talking with him because you said that you don't want to scare him.
No,
Correct.
ma'am. I didn't shoot any video or anything of that nature.
You know, no audio.
No, ma'am.
So this is just your recollection of what took place.
Yes, ma'am.
And you're hired, did the attorneys tell you what they wanted you to do?
They gave me an assignment to see if I could find Jermack Jones and interview him about the murders of Doris and Nishonda Washington.
And he basically told you he knew nothing.
Ma'am,
And he basically said he didn't know about the murders.
well, what I just read is what he said.
But you have no way of verifying that.
Through this affidavit, my testimony.
Okay. So were you able to review any of the evidence in this case as a private investigator?
No, ma'am, I haven't reviewed any evidence in this case.
What other investigatory duties did you have with regard to this case?
I think I'm going to run some background checks on some witnesses, and then this.
You ran some background checks on individuals?
I may have, I'm not 100% positive.
Did you take notes on that?
Did I take notes on that? If I did, it was passed up. whatever the results were.
Okay. And were you asked to look into any aspects of this case? When you investigate, as a private investigator, you're basically kind of going back and looking at all aspects of cases, correct? Like,
Well,
when they
basically,
hire
I'm
you
doing
to
what I'm asked to do.
you're only laser light focused, like this is what I do, is like I will just go up and talk to this person in a vacuum and you know nothing else about it? They don't give you any other premise or any other basis on what you were asking this person about?
I got a summary of the case. you know,
Okay.
A verbal summary of the case.
A verbal
This is
summary
what
of the
we were
case?
looking
When you get verbal summaries of the cases, do you ever go back and look at the case that you're investigating?
Depends on how much more I'm doing in it or what I'm doing in this particular thing. I just went with the verbal because I didn't know how much I was going to be doing in the case. And
So did you ever go back and look at the newspaper articles from this case that were readily available in the library? Do you ever do any of that kind of work as part of your investigatory skills and responsibilities?
I do if the client requests me to.
Excuse me, sir?
I do if the client requests.
You do at the client's request, so you don't go back and do any research whatsoever, backstory, and find out what it is that you're working on?
Depends on what the client wants me to do.
It depends on what the client wants you to do and what they want you to get, correct?
Yes.
Yes.
Okay.
Thank you. Your Honor, no further questions for this witness.
All right.
One
Any other
quick
questions?
follow-up. Ms. Ellis mentioned that police officers are required to record suspects in homicide cases during interrogations. You pointed out that's a recent statute. They're not required to tell people they're being recorded, are they?
To my knowledge, they don't have to.
And in fact, the testimony in this case is a recording of Mr. Jones was made without his knowledge using a camera that was hidden in the thermostat in the interview room.
That's what I heard.
And of course, you, as a private investigator, didn't have the power to bring Mr. Jones to a facility where you could hide cameras
No,
and record it. You were meeting him at a Burger King,
that's correct,
a
sir.
public place at his request.
Yes, sir.
I have no further questions.
Just a couple of clarifying things. So are you taught in private investigator school the laws of how to, I mean, you're taught how to photograph people surreptitiously, correct?
Well, I don't know about private investigator school. I never attended a private investigator school.
Well, you said that you had continuing legal education, continuing,
That's correct.
so that way you know what you're doing to not break the law when you're doing what you're doing.
Yes, ma'am. You read up and make sure you're not breaking the law.
Okay,
Sure,
so you
not the intent to go break-
learn techniques on how to surreptitiously take photos of the cheating husband or wife, correct?
Well, I don't know about the cheating husband or wife.
Okay. And you also know that North Carolina is, as long as you know that you're recording, the other person doesn't have to, correct?
Yes, ma'am. That's my understanding.
So in the course of your investigations, it's pretty easy for you to slip a small recorder in your pocket and memorialize very important interviews, correct?
I don't know how easy it would be.
Excuse me?
I don't know how easy it would be.
You don't know how easy it would be to press a button and put a small recorder in your pocket and conduct an interview that could be memorialized?
No, because I'm dealing with people that, if they saw it, we could have a confrontation, and that was not my intention to record anything.
At a Burger King? So you're saying that no investigators do that because
I don't know what other investigators do.
you don't know any other investigator who takes the steps that they need to do to memorialize their interviews in major cases?
Like I said, I don't know what other investigators do, ma'am.
Interesting. Your Honor, no further questions.
I have no questions.
All right, you can come down.
Your Honor, I'd like to move into evidence Mr. Waller's affidavit, Defendants Exhibit 37.
So,
Your Honor, we also rest our case with respect to the newly discovered DNA evidence and the exculpatory evidence that flowed from the codicil.
all right, will there be evidence from the state?
Your Honor, if we can have a moment. Your Honor, the state will not be putting forward any evidence for this portion of it. However, we would ask for a short recess if they're going to go into opening and closing at this time.
How long a recess is short? How long do you need?
Probably a half an hour.
We're ready to go, Your Honor. We'd like to get this going. It was 5 or 10 minutes, obviously no problem. I think a half an hour is a little long. We'd like to, because we've got another hearing to do after this, but obviously in the court's discretion.
Well, I'll give you a chance to get your thought together. Why don't we take 15 minutes?
Thank you, Your Honor.
Mr. Frazier, I need to see you about something. 15 minutes.
Court's in recess, 15 minutes.